Hello, everyone. Thank you for joining us to this webinar on a Saturday. Hope you and your families are keeping safe. Today's webinar is on the topic Vodafone versus India, Next Steps and Lessons Learned. This webinar is hosted by the Young SIAC. I'm very delighted to welcome you all and our wonderful lineup of speakers. You're welcome to send in your questions for the panelists via the Q&A functions. As we have limited time, the panelists will try their best to address as many questions as possible. Without further ado, I will now invite Piyush Prasad, our counsel at SIAC, to introduce the panelists and hold the fort for the webinar. Piyush, over to you.
Thank you, Shweta. As Shweta mentioned, I'm Piyush and I'm a counsel at the SIAC Secretariat, and I'll be the moderator today. The panel today will discuss the much talked about Vodafone versus the Union of India Bilateral Investment Treaty Award, in which the tribunal made the award on 25th September 2020. That was 64 days ago. I calculated the days since the making of this award because there is news that the Indian government is considering challenging the award in Singapore, which is the seat of the arbitration. Now, under the Singapore International Arbitration Act, a party has 90 days to make that challenge. Therefore, the arbitration has concluded, but whether the dispute in reality has come to an end is a billion-dollar question. Discussing a few of these interesting aspects surrounding this arbitration, on the panel we have first Ms. Shama Loya, who is the leader, International Dispute Resolution, Bishop Desai Associates. Shama will provide the genesis of the dispute and the invocation of the arbitration. Hi, Shama.
Hi, everyone.
Next, we have Ms. Neeti Dixit, who's a partner at FNR Associates. Neeti will give us an overview of the parallel arbitration as well as the Indian court proceedings. Good afternoon, Neeti.
Hi, good afternoon.
We also have Ms. Kate Apostolova, who's a senior associate at Freshfields. Kate has been ranked #1 on Who's Who Legal's most highly regarded list of non-partner international arbitration practitioners in the Asia Pacific for 2020. Kate will give us an overview of India's investor-state experience and lessons learned from this arbitration from an investor-state perspective. Hi, Kate.
Hello. Thanks all for joining us.
To round up our discussion, last but not the least, we have Dr. Rishabh Gupta, partner at Shardul Amarchand Mangal Das. Rishabh has the challenging task of crystal gazing to predict what will happen next in this dispute. Welcome to the webinar, Rishabh.
Hi, thanks, Piyush, and welcome everyone.
Before we begin, on behalf of the panelists, I would like to note that, as everyone knows, the award is confidential. More importantly, the Vodafone India dispute only forms the background of this discussion. We will discuss the general legal principles based on what is known about the case in the public domain. In terms of format, we have 1 hour for the discussion, followed by 15 minutes for the Q&A session. We invite the invitees, as Shweta mentioned, to use the chat function to send their questions, which, depending on the flow of the discussion, we'll either take during the discussion or take them up at the end of the towards the end of the discussion. Shama, let me begin with you. At first blush, this looked like a tax dispute before the Indian courts. However, it snowballed into a bilateral investment treaty arbitration before an international tribunal. Before we take a deep dive into the resulting issues, could you give us some background about this case?
Sure. Firstly, thanks Piyush and YSIAC for organizing this webinar. My apologies that I will need to excuse myself after my talk as I have to meet an urgent commitment. Now, India has been involved in more than 25 investor-state disputes right from the 1990s and broadly distilled into 4 categories: claims by foreign energy and mining companies, by foreign telecom companies for revocation of 2G spectrum licenses, by foreign space and telecom companies for cancellation of S-band electromagnetic spectrum lease, and lastly, claims by telecom and energy companies for retrospective taxation of capital gains. Vodafone falls in the last category, which is one of the most unique categories in the field of investor-state arbitration, where a country's executive made a tax demand which was quashed by the country's judiciary, but was subsequently overridden by the parliament by way of a retrospective legislation that reinstated the tax demand. So let me give you a background of the Vodafone case now. In 2007, Hutchinson Telecommunications International Limited, which was a Cayman Islands entity, let's call it Hutch, sold its stake in CGP Investments, another Cayman entity, to Vodafone International Holdings, which was a Netherlands entity, for a consideration of around $11.1 billion. Now, Hutch earned capital gains on this sale to Vodafone Netherlands. CGP Investments, that is the sold Cayman entity, held various underlying subsidiaries in Mauritius. These, along with certain Indian companies, ultimately held 67% stake in Hutchinson SR Limited, which was an Indian company. Now, the Indian revenue authorities considered that Vodafone Netherlands' indirect acquisition of shares in Hutchinson India was liable for tax deduction at source under the then existing provisions of the Indian Income Tax Act of 1961. As Vodafone Netherlands had failed to withhold Indian taxes on payments made to Hutch, a tax demand of $2.1 billion was raised on Vodafone Netherlands. Now, this demand was challenged by Vodafone in the High Court of Bombay. The High Court pierced the corporate veil and upheld the tax demand. This was challenged by Vodafone before the Supreme Court of India. On January 20, 2012, the Supreme Court held that sale of share in question to Vodafone did not amount to transfer of a capital asset within the meaning of Section 2, Subclause 14 of the Income Tax Act, and the Supreme Court quashed the demand. But soon after, in March 2012, after the Supreme Court's judgment, the Indian Parliament amended the Income Tax Act so as to retrospectively clarify that a capital asset being any share or interest in a company or entity registered or incorporated outside India shall be deemed to be and shall always be deemed to have been, since 1961, situated in India, if the share or interest derives directly or indirectly its value substantially from the assets located in India. And hence, indirect transfer of such assets attracted capital gains tax, as it happened in the Vodafone case. This is the crux of the dispute, and which finally led to invocation of arbitration by Vodafone Netherlands under the India-Netherlands BIT. Piyush.
Thanks, Shama. That's very useful to know the background. So what I hear is that, of course, there was litigation in India with the government winning in the Bombay High Court, subsequently losing before the Supreme Court, and then the invocation of the BIT under the India-Netherlands the bilateral investment treaty. How did this jump happen from the loss before the highest court in India to the invocation of the BIT?
Right. So, Piyush, as I mentioned, we are looking at a case where Vodafone challenged the tax demand all the way up to the highest court of the land, had a decision in its favor from the highest court, and then the unexpected happened for the foreign investor, where the Indian Parliament overrode the Supreme Court and effectively reinstated the demand. Now, in such circumstances, Vodafone could either challenge the constitutionality of the retrospective legislation, now, which would be chartering into uncertain territory and picking up a tricky and arduous battle, I would say, again, before the Indian courts. The other alternative, when a state's organs act in a seemingly arbitrary and unfair manner against a foreign investor, is to invoke treaty protection under an international investment agreement, which is what Vodafone did under the India-Netherlands BIT. That's the jump it made.
Interesting. So it had two options, and Vodafone chose to invoke the bilateral investment treaty under the treaty between India and Netherlands. Now, can you give us a brief background of, we know that the award is not in public domain, but there have been reports about what has been the decision of the tribunal, which came out in September this year. Could you give us some idea, some color of what the decision has been?
Sure. So the dispositive part of the award is in public domain, and the tribunal effectively held that India's conduct in imposing a tax liability, interest and penalties on Vodafone Netherlands, notwithstanding the Indian Supreme Court's judgment, is in breach of the fair and equitable treatment guaranteed under Article 4, Subclause 1 of the India Netherlands BIT. And accordingly, India has an obligation to cease its conduct on imposing the tax liability on Vodafone, and failing which India would be engaging its international responsibility. The tribunal also directed India to reimburse 60% of the claimant's legal costs and 50% of the costs it incurred towards the appointing authority. Now, a lot has been written and discussed about the Vodafone versus India dispute since the dispositive was published on September 24. But the detailed aspects of the decisions will only come to fore if and when the award will be challenged by India and Singapore, because that's when we will know the manner in which the tribunal has dealt with issues in the case. Piyush.
Yeah. If I just may ask you, like, it sounds like India also challenged the jurisdiction of the tribunal, and like from what is available in the public domain, the tribunal seems to have rejected India's challenge to the jurisdiction and has gone ahead and made the award. Can you tell us on what basis did India challenge the jurisdiction of this tribunal?
Sure. So the documents involving India's challenge to the invocation of dispute and challenging the jurisdiction of the tribunal, again, not in public domain, but what we know from, mostly the judgment in the proceedings before Indian courts is that India challenged the invocation of dispute on the ground that disputes relating wholly or mainly to taxation are excluded from the scope of the India Netherlands BIT, and that notices of disputes served by Vodafone to the government of India under the India Netherlands BIT are not valid, as the alleged disputes are outside the scope of the BIT. So that's the jurisdictional objection that India took.
Right. I mean, if you look at the model BIT, the latest edition, it looks like India has sort of made it abundantly clear, if it was not already clear, that such disputes will be outside the purview of BIT arbitration. Thanks so much, Shama, for laying out the background to this dispute.
Thank you so much, Piyush. And my apologies that I will now excuse myself unless you have any further questions.
No, I will WhatsApp you if there are any other questions. Thanks for joining us.
Thank you so much, everyone. Thank you.
So we can move on now, and from what Shama alluded to, that this was not just an arbitration, dispute fought before an arbitral tribunal, but it seems to have, spent some time in the courts in India as well. Of course, we've seen the aspect of the tax litigation being fought in Bombay and before the Supreme Court in Delhi. There seems to have been some other parallel proceedings as well, and I'll turn to Niti next. Shama mentioned about the invocation of the India Netherlands BIT in 2014. But we also learned subsequently that Vodafone also invoked the India UK BIT subsequently in 2017. Now, I'm a bit confused as to how can Vodafone invoke not just one but two different BITs. Niti, can you throw some light on what happened, what transpired?
So hi, and thanks Piyush for having me here. So it's I mean honestly, I think one of the lessons you learn over time is litigation is just fundamentally unpredictable. I'm sure Vodafone, when they originally invested in India, came in hoping to run a telecom company and seemed to have spent a lot of time fighting cases in the courts in India. But this was an interesting, actually, and it's not over because there is an appeal still pending in the Delhi High Court for a division bench. But what appears to have happened, and there are the orders of the Delhi High Court are obviously publicly available. So when you read them, what you get is the following. Originally, as Java had just mentioned, the investment was made through a Dutch entity, Vodafone International Holdings, registered in the Netherlands. And therefore, the BIT that was relied on to initiate proceedings was the Dutch India BIT. That appears to have a particular provision relating to tax claims. And when the notice of arbitration was issued sometime in 2014, though the original notice of dispute Vodafone actually sent in 2012 itself, the notice of arbitration was sent in 2014. India responded to that, objecting to the jurisdiction of the tribunal on the basis that there was a tax exclusion, and that's what it appears from the record. It is in those circumstances, in the light of that objection, that it appears that Vodafone then, so in the chain of entities, there is obviously the parent entity, which is a UK company, that a notice of dispute was issued under the UK India VIT. It appears from the judgment that, and the Delhi High Court actually relies on that ultimately when we finally come to the judgment and they vacate the interlocutory injunction that they had issued. One of the reasons that they said that the multiplicity of proceedings is not problematic is because India objected to jurisdiction in the first instance. The reliance on the UK India BIT by Vodafone to issue a subsequent notice of arbitration was understandable. So that is the context in which the second notice came to be issued. And then that in turn led to India approaching the Delhi High Court.
Right. Now, in fact, I was just going to turn to that because, of course, like any defendant, India defending, the invocation of these BITs, the reaction is to oppose them. You have India opposing the first one and also the second one, and which leads to the Delhi High Court. In fact, you mentioned about the Delhi High Court first initially granting, in fact, an ex parte interim order enjoining Vodafone from going ahead with the second BIT, but which was subsequently, vacated with a pretty detailed order. And you mentioned that proceeding, the appeal before the division bench is still pending, and I believe the next date is 8th December in that matter. I wanted to pick your brains on, if you can tell us as to the considerations of the Delhi High Court initially granting the injunction. You touched upon some of them. I'm more interested in sort of knowing what changed. Delhi High Court initially granted it and then subsequently vacated it. And there are other instances also where the Union of India has made applications for stopping, BIT arbitrations, and the Delhi High Court has not granted it. So if you can tell us about the considerations that the Indian Delhi High Court specifically had initially while granting it and then subsequently vacating it.
So, and I think when you say that it was ex parte, I think that sort of explains the context. The single judge seeing an ex parte application has no information other than what is available on the bare bones of an Order 39 application. And so the judge proceeded in the interlocutory order. He proceeded on the basis that this was essentially a tax dispute which should have come to the national courts. There is something fundamentally unfair in allowing two arbitrations to proceed, because the order of the single judge, the interlocutory order, actually sets out the reliefs that are claimed in both the notices of arbitration, and which is where we get their information in the public domain. And the reliefs appear to be identical. They appear to be. I can't say if they are fully identical, but roughly they seem to tread the same ground. And so the judge, and any judge looking at that would say, well, what's going on here? It's the same single economic entity in the same corporate chain, and you're using two separate entities to drag India to an arbitration for the same relief in two fora. Now, two, obviously a domestic court, and under domestic law that would appear to be forum shopping. It doesn't work the same way, as we all know, in public international law and with BIT claims, and as the single judge himself subsequently acknowledged in his inter partes order. So the first interlocutory order is ex parte. The judge has limited information available before him. What appears to him is this seems to be two proceedings on identical relief. It appears inequitable to the judge. There's a duplication, he says, of parties and issues. Um, um, and there is a single economic unit which is trying to approach different courts. So he issues a restraining order. It has limited effect because the stage at which that order was issued actually was at the stage at which the tribunal was being formed, and India had not made an appointment and had gone to the Delhi High Court instead. It seems from the subsequent order that the appointing authority, which is the president of the ICJ, continued with the process and said that if India did not make its appointment, the appointment would be made. So in fact, India does make the appointment subsequently, and the tribunal does get constituted, even under the UK-India BIT. And then matters, I think everybody stays their hands till the Delhi High Court in a few months actually hears the matter inter partes. And the interesting thing is that on each of those points on which the single judge had actually issued the interlocutory injunction, after hearing arguments on both sides, and also inviting an amicus to come and assist the court and give a sense of what the law should be, the judge takes a completely different view and examines extensively. It's a very interesting judgment, actually, that Justice Manmohan has rendered, where he examines extensively the sort of obligations of parties in a BIT and the obligation of a court. I mean, I think that I don't know if ultimately what will happen in the appeal and how the courts are going to view it. But that was the first time that the Delhi High Court considered the impact of a BIT and how Indian courts will look at it. I just want to, if I have time, just make a couple of points about the judgment of the single judge.
Sure, Neeti, we have time. Please go ahead.
So I think the important point that he makes, and is the most important point that he makes, is that the Indian courts, in the view of the single judge, have an inherent jurisdiction to restrain an international treaty arbitration, but in very exceptional circumstances. So he believes that the judge takes the view that the courts have retained that jurisdiction. And he comes to it by a process of analysis where he says that a BIT arbitration is not a commercial arbitration, which is covered by the Arbitration Act, the Indian Arbitration and Conciliation Act. Now, if the Indian Arbitration Act had applied, actually the Indian court would not have jurisdiction to restrain an arbitration. The principles of competence apply. You would have to fall within the test of, say, Section 45 of the Indian Arbitration Act in order for an Indian court to step in. So he acknowledges that an Indian commercial arbitration, which is a foreign seated arbitration, would actually have better protection in that sense. And because it falls outside of the domain of the Arbitration Act, the inherent jurisdiction of the Indian court under the Code of Civil Procedure then steps in, and the Indian court has inherent jurisdiction if you can find subject matter jurisdiction, or you can find jurisdiction in personam over the entities. Then they would have the jurisdiction to issue an injunction. He does, however, make the point repeatedly that this would happen in exceptional circumstances. It would have to be a vexatious proceeding. He gives examples of a vexatious proceeding. He says, for instance, an investor who has lost a case on merits under a BIT claim, but the same investor tries to bring another proceeding that may be vexatious. So he does set out a very, very strict parameter. And we find that parameter is then applied subsequently. As you mentioned, there is a subsequent case brought by the Union of India in relation to Loop Telecom, which does not concern retrospective taxes, that is in connection with the cancellation of telecom licenses. The Union of India tries to restrain another arbitration, which is brought by a Mauritius-based entity on other grounds. And the Delhi High Court relies on similarly, another single judge relies on this view, applies this view, rejects the injunction, does not grant the injunction. So that Delhi High Court seems to be taking a view not to apply a very strict standard, but it has not declined jurisdiction. And I think that is the point that investors should pay attention to, that they have retained jurisdiction to restrain a BIT in exceptional circumstances, but it can be done.
Right. That's very interesting, because Delhi High Court seems to recognize, of course, competence, that, the jurisdiction is, of course, the prerogative of the tribunal itself. And Section 5 of the Indian Arbitration Act also says that, look, courts should not intervene where it's not recognized specifically or as provided in the Indian Arbitration Act. So there is, at least as far as statute is concerned, what it prescribes that do not, courts should hold their hands off. But the High Court, initially granted the injunction and then vacated it for good reasons. I think that's a result that we're all probably happy about. Rishabh, if I may ask, you advise a lot of foreign investors in India. This reaction from the Delhi High Court, as in how would you go about advising a client who is trading both in India as well as in international treaties? What would your advice be as to how this can possibly play out? Because what Niti mentions is about exceptional circumstances. Now, there's no definition of that, and it can play out in any way that almost sounds like the unruly horse to me. How would you advise your client in a situation like this?
Yeah, thanks, Piyush. Look, I think Niti has already set out quite clearly what the judgment was. But just stepping back a second from all of this, it's not that unusual that you would find the same investor across a corporate chain commencing multiple investment treaty arbitrations, right? This may have been India's first experience, but there are loads of examples out there of similar things happening. Perhaps the best known one is Lauder and CME arbitrations against Czech Republic, which were in respect of precisely the same laws brought by two separate entities, one by the ultimate shareholder and the other by the group entity against Czech Republic. And the relief sought were identical as well, which was basically damages. So, from that perspective, while Vodafone did seem to be sort of totally out of the ordinary, that how could you be commencing two arbitrations under two separate BITs in relation to the same events? As far as investment treaty law goes, that's not very unusual. And that's the product of having a decentralized system, right? You would never have it in the WTO context, for example, because you have a single treaty that applies across the board to all countries. But that's not what BIT is. We don't have a multilateral investment treaty. So that's just the starting point that, I know at that point of time, a lot of people reacted to it in a way that how could anyone ever do it? But that's how it works. And states have opted into that decentralized system. So they should anticipate this as well. Now, coming to the judgment in particular, the part about the injunction, I don't find anything wrong in what the judgment has said. And I think that's what Niti was also saying. The principle that a national court retains jurisdiction to injunct an arbitration, which in the judgment's words are either vexatious, inequitable, oppressive, or abuse of legal process. Those are fairly well-known principles, at least under Indian law, and those apply to commercial arbitrations as well. So if you were to go to the Delhi High Court to obtain an anti-arbitration injunction in relation to, let's say, Singapore-seated commercial arbitration, you'll have to meet exactly the same standard. And I'm not really sure why that standard should be any different when it comes to investment treaty arbitrations, because ultimately the principles are identical, right? let's not forget that investment treaty arbitrations are different to commercial arbitrations only because the actors are different and the governing law is public international and the consent comes in the treaty. But in all other respects, as far as procedure goes, it's identical, which is why, and that's where the judgment, I think, gets it wrong, which is why the same Arbitration Act applies. And that's what every jurisdiction does. I mean, you go to England, you go to Singapore, any other jurisdiction which has considered investment treaty awards has not said that there's a separate domestic regime that has to be built to consider how those treaty awards need to be treated, how those treaty awards need to be enforced, or if the time comes, how those treaty arbitrations need to be injuncted. So the exceptional circumstances, Piyush, that you talk about, those are precisely the same exceptional circumstances that we advise clients about day in and day out when they're commencing a commercial arbitration. What would those be, for example? If there is no arbitration agreement, yes, a court should injunct you. Yeah. So if, I mean, take SIAC's example, you have, you also, when an arbitration is commenced in pursuant to, let's say, SIAC arbitration clause, if there is no SIAC arbitration clause, you won't register it, right? In the same way, if there is no arbitration clause, a court should injunct it. Now, equally, if there is no relevant treaty that applies, the court might injunct it, the Indian court might injunct it. Now, is that something which an investor should be bothered about? Not really, because, I mean, that's really malpractice on the part of the council to lead you down a path where there is no arbitration clause that applies at all. So, to be honest, I'm not too bothered about that aspect of the judgment at all. It's bang on, it's the right judgment. It simply says the same principles apply to injuncting an investment treaty arbitration as they would to a commercial arbitration, and that, to my mind, is the right jurisprudence. The problematic jurisprudence is the other part, where, sort of strangely enough, the court reaches a decision that somehow the Arbitration Act doesn't apply here. I'm sure Niti would talk about that in any event. But on the first part, I think the decision is bang on, and I've never had any difficulty advising anyone in relation to that, because that's what you do day in and day out for commercial arbitrations as well.
Right. Thanks, Yusuf. I mean, if I hear you right, so of course you are fine with the Delhi High Court or the Indian court, retaining that power, of course, in exceptional circumstances to injunct an arbitration, of course, and we are talking about, I mean, I would say extreme circumstances where, of course, there is no arbitration agreement. And I hear you on that, and that's pretty much standard. Of course, under the SIAC rules, there is that rule 28.1, where we see whether the arbitration can proceed or not. But the question here is that the Vodafone arbitration was not seated in India. I mean, Shama mentioned that this is seated in Singapore, and the challenge, the set aside would be in Singapore. But here is a situation where the Delhi is not the seat. The Delhi High Court is not the seat, yet Delhi High Court assumes jurisdiction to pass it does initially injunct and later on vacate it. That seems to be a troubling part to me, at least. How would you react to that?
No, it doesn't sound troubling to me at all. The Delhi High Court can injunct, and remember, the injunction is always against the parties, right? It's not an injunction in isolation. You're injuncting a party. So if you have a Singapore-seated commercial arbitration, of course, the courts of the seat are Singapore courts, but to the extent the Delhi High Court, under the rules that apply, which pursuant to CPC, has jurisdiction, then of course it can issue an anti-arbitration injunction, right? Now, what standards would apply is a different question. You got to divorce the two questions, right? You got to divorce the question of jurisdiction, which doesn't come from the Arbitration Act, which comes from the CPC, the Code of Civil Procedure. And then you have to ask yourself that what are the standards that apply? And all I'm trying to say is that the analysis, in my view, is identical, whether it's a commercial arbitration or treaty arbitration. And therefore, in the same way as Piyush, you would not have asked me this question if there was an arbitration between, let's say, two Indian parties seated in Singapore. Leave aside the question whether two Indian parties can arbitrate a fraud. But let's say there are two Indian parties seated in Singapore. One of them runs to the Delhi High Court to seek an injunction. Now, no one would go before the Delhi High Court and say, look, where is the jurisdiction? Everyone would say that, look, you shouldn't do this because let the tribunal decide, right? And in my view, the analysis is the same. There's no reason why an investment treaty award needs a fresh set of rules and jurisprudence, which would have to be created specifically for this. Because as far as national law is concerned, the same rules should apply. That's my view, and I think that's why I think the judgment gets it right in the first part and gets it wrong in the second part.
Right. Thanks, Grisham. So it goes back to what Neeti, you were mentioning. Of course, seat court will have jurisdiction, but you mentioned about the subject matter jurisdiction. I mean, if you are within the territorial jurisdiction, that court will have jurisdiction, and of course, it should sparingly apply that. But do you agree to Rishabh's assessment that the second part of the Delhi High Court judgment doesn't get it right?
I think I find it troubling at a slightly different level, and I think what does it mean for instance, if a BIT was to be seated in India? It's possible. Why do we as Indian lawyers, judges, arbitrators, practitioners assume that India is not that jurisdiction where a BIT could be seated? It would therefore have to be two countries not related to India, but choosing India as a seat, because India is, is that hub where there is limited, there's sophisticated practitioners, etc., etc. Why now? What the end result of saying that the Arbitration Act doesn't apply means there is no basis now for somebody to seat an arbitration in India, because how would they challenge an award? There's now no seat left. No domestic law framework within which you could actually operate. So India has effectively rendered itself out of the race for being treated as a fair, neutral jurisdiction for a BIT arbitration for two other countries who may feel that India, given its sort of sophisticated common law understanding, its practitioners, its judges, this would have been a very good place for you to seat a regional arbitration, for instance. But by saying that the Arbitration Act doesn't apply, frankly, you've left parties in an investment treaty arbitration seated in India without remedy. It doesn't matter to these BIT claims, because these are all seated elsewhere. India is obviously not a jurisdiction, a seat for these arbitrations, because India is a party. But so to me, actually, at a conceptual level, it troubled me. Why do we want to be perceived as a jurisdiction that doesn't actually have a legal framework which would support an investment treaty arbitration if somebody was to choose India as a seat? And I think that's one of the things that has happened. So that's why I find the judgment troubling for that reason. Quite apart from the fact that, this is one view that the judge has taken. There is still an appeal that, there's also the other case is still pending, where the single judges, so in the Vodafone Delhi High Court proceedings, the single judge actually disposed of the suit. But in the other matter, the Loop Telecom matter that I was mentioning, that matter will come to trial. These issues could possibly come up in that matter and be decided. So there is no, these issues will attain finality in due course. I'm not saying that this is the final view of the Indian courts. This is a view, and it's certainly a well-reasoned judgment. I mean, it's not as though the judge has not thought through these matters. I think he's done actually quite a thorough job of looking at the arguments that were placed before him, and he's taken a view. I don't necessarily agree with the view that the Arbitration Act doesn't apply. But as I said, to me, what struck me was, we've done ourselves, we've put ourselves out of the reckoning as a seat of arbitration, because now we have no framework. We now are left to somebody who wants to challenge an award seated in India, for instance, would have to file a civil suit in the Indian courts. I mean, how would that play out?
Right. I mean, I will turn to the enforcement of the BIT awards in the later part, but let me turn to Kate now. Kate, I mean, looks like there are issues, with India being involved in BITs, as both Neeti and Rishabh mentioned. Now, there is no framework, it looks like, if you have, a BIT concerning India, and if you are in India, you have experience of representing both states and investors in, various BIT arbitrations. Can you tell us briefly about India's experience specifically with investor-state arbitrations?
Certainly, yes, Piyush. Let me I don't know if I can do it briefly, but let me try. India has quite a long and eventful history in investor-state arbitration, so we can spend a really long time talking about it. But let me just make 3 points, highlighting some more recent examples. The first point is that in the last several years, there has been a significant shift in India's investment protection regime. And that really came about because of a number of arbitrations brought against India. And this trend started in 2011 when India lost its first investor-state arbitration, which was brought by White Industries of Australia and related to excessive judicial delays in enforcing a commercial arbitration award against through the Indian courts. So the tribunal there found a breach of the effective means provision. So not the fair and equitable provision which was used in Vodafone, but the effective means provision which White Industries imported from another treaty through the most favored nation clause in the Australia-India BIT. So this was the first BIT claim lost by India. Before White Industries, there were about 9 reported BIT cases against India, and India settled all of them. Following White Industries, there were at least 15 new investment treaties against India, challenging India's actions in a number of industries, as you heard Sharma say as well. And the latest case, which was reported a couple of weeks ago, which was filed by a Mauritian entity in relation to airport ground handling services, where Freshfields actually represents the claimant. So for several years, India was one of the most frequently named respondent states in investor-state arbitration. And that prompted India to reevaluate its investment treaty program. So what India did was it terminated almost all of its BITs, starting in 2016, and then in 2017, it terminated 58 of its about 85 BITs, and up to now, it has terminated 69 BITs. And it has tried to renegotiate them according to its newly adopted model law, which Piyush, you mentioned. And the new model law really introduces significant changes in India's prior model law. As you mentioned, the model law doesn't cover tax disputes, so that was likely intended to foreclose bringing arbitrations like the Vodafone and Vedanta Resources arbitrations. It has deleted the fair and equitable treatment standard, which was invoked by Vodafone, has deleted the most favored nation clause, which was invoked by White Industries, and it requires investors to exhaust local remedies before they bring arbitrations against India. So since India terminated its BITs, it has signed 5 new BITs, which adopt some of the features of the model BIT, not all of them, but some of them. And those 5 BITs are with Cambodia, Belarus, Kyrgyzstan, Taiwan, and this year with Brazil. So none of the big countries with which India, which invest in India, really did India renegotiate the BITs yet. But it's important to note that even the terminated BITs might still provide protections for some investments because they do have sunset clauses which protect investments that were made in India before the termination date of the BIT. So for example, last year the Indian government revealed that it was facing an investor-state arbitration from a Portuguese investor under the India-Portugal BIT. And even though the India-Portugal BIT was one of the BITs that was terminated in 2017, alongside the 58 other BITs, the BIT contains a 15-year sunset clause, which protects investments made in India before the BIT termination in 2017. So the Portuguese investor may be able to bring this claim against India if the investment was made before the termination date. For the remaining BITs, you recall I said India has about 85 BITs and it terminated 69 of them. For the remaining ones, it could not or it cannot yet terminate them because they haven't completed their initial term. So they're not ripe for termination. But India has circulated a proposed joint interpretation statement to its counterparties to the BITs, seeking to align the model BIT with the existing older BITs and to prevent expansive interpretation of that BIT. And it has signed 2 of those so far with Bangladesh and India. So the second point I wanted to make is about how successful India has been in investor-state arbitration so far. And the answer to that is not very successful. Based on publicly available information, India has won 1 arbitration, I believe, and that is the LDA versus India arbitration, which was brought by a French investor and for a relatively small claim of 36 million US dollars under the India-France BIT. So in that case, the tribunal dismissed the claim, and it was reported that the claimant was ordered to pay India's legal fees as well, about $7 million. So it was a complete win for India. Most of the cases India has settled, so at least 10 investment arbitrations it has settled. Just in May of this year, it was reported that India settled its claim with Nissan after a state government agreed to pay up to $238 million to end the investment treaty claim, which related to a promised incentives to Nissan to build a car factory in India. So Nissan filed the treaty claim in 2017. It alleged breaches of the fair and equitable treatment standard. The tribunal upheld its jurisdiction, which India robustly challenged, and India was in the process of challenging that jurisdictional decision in the Singapore International Commercial Court. But in May of this year, it settled the claim. It also settled at least 8 claims by banks, including BNP Paribas, Credit Lyonnais, Standard Chartered, and all of them related to the bank's loans in relation to a power project in India. And obviously it has lost a number of arbitrations as well, including the one that we are discussing today, including Deutsche Telekom, which Freshfields represents the claimant, and the tribunal found a breach of the fair and equitable treatment standard, and which finding India also challenged in the Swiss Federal Supreme Court, where the challenge was refused, and the arbitration is now in the quantum phase. And my last third point that I wanted to make is about India's track record of complying with arbitral awards against it. And unfortunately, again, it's not a very good track record. There are a number of awards against India which remain unpaid. And as I pointed out in some of the examples I gave, India has sought to challenge those awards and has sought to resist enforcement of those awards as well. So for example, there is an award in 2011, from 2011, in Vedanta and Rava Oil versus India for $278 million by a Kuala Lumpur seated tribunal. And it remains unpaid to date. So what India has done is bring a challenge to the award in Malaysia, which was dismissed by the High Court. That decision was upheld by the Court of Appeal. India brought it to the Federal Court in Malaysia, which is the equivalent of Supreme Court. And that upheld the decision of the High Court as well, dismissing the challenge. And India still did not pay the award, so the claimants brought a case in the Delhi court to enforce it. India challenged the enforcement on the basis of statute of limitation, arguing that the award should have been enforced 3 years after it was issued. And this also went up to the Supreme Court in India, and the Supreme Court just in September of this year found that the enforcement was lodged in good time. So I think we're maybe likely to see the same type of challenges in resisting enforcement in this case, but we'll hear more about that next, I think.
Looks like that. Kate, I wanted to ask you, you mentioned about India and the model BITs, deleting the portion on the fair and equitable treatment, which seems to be a commonly invoked provision in various BIT arbitrations. And especially in this case, the state's sovereign power of taxation, which is at the heart of this and some other cases which are known in the public domain. Now, how would you say that the fair and equitable treatment interacts with the state's sovereign power of taxation?
That's a good question and a difficult one to answer. I mean, obviously, a state has the power to tax. No one would say otherwise, I don't think. And as part of the state sovereign power, a state can impose tax not only on its nationals, but also on foreign investors that invest within its territory. But there are limits to state power and to the state power to tax. And those limits arise from international law and also including from the substantive standard of fair and equitable treatment. So I think there are two main limitations that the fair and equitable treatment standard imposes on taxation. One is the taxes cannot be against the legitimate expectation of the investor. And two, that taxes cannot be discriminatory. So I think those are the two main limitations. But just to be clear, those limitations do not guarantee to the investor that the tax regime will not change. So the tribunal in Pushok versus Mongolia, for example, did expressly say if the investor doesn't have an agreement with the state to not prohibiting increasing the taxes, the investor should not be surprised if they're hit with tax increases in following their investment in the country, and that such an event is not unpredictable. And in that case, the tribunal found that Mongolia did undertake what it called a radical change in the tax regime. And it also found that that radical change caused severe negative impact, and that's what the tribunal called it, a severe negative impact on the industry as a whole and the claimant's business as well. But it still said that the enactment of that tax was not contrary to the treaty. So the tribunals have tried to strike this balance between the state's power to tax and the fair and equitable treatment of foreign investors as well. And typically they require that there are some specific assurances or promises by a state on which the investor reasonably relied and decided in deciding to invest. So I think we can all appreciate that this determination of whether a specific tax change is a violation of the treaty would depend heavily on the facts of the specific case. There are awards out there where tribunals have found that tax measures violate the treaty, so such as the Vodafone award and Occidental v. Ecuador as well, but there are also awards that find that the change in tax regime did not violate the treaty, such as the award I mentioned against Mongolia and Anglo-America versus Venezuela as well.
Right, thanks, Kate. Before I move on, Bishop, I wanted to check with you. Kate mentioned about a number of BITs against India. Would you like to comment or let us know what your experience, has been, or what you think about India's experience with investor-state arbitration?
Yeah. No, look, I agree with everything Kate said. I mean, those are largely facts, so there's nothing to disagree on. But I think there's, but there's one, there's an additional dimension to it, which I think is worth keeping in mind, which is that, see, ultimately, at least in my limited experience, the government is very serious about trying to strike the right balance, and that's a problem which is not specific to India. I mean, most countries have that issue, where they all signed up to these BITs, especially in the 80s and the early 90s, with very limited understanding of precisely what they would entail. And most empirical studies that have been done in this area confirm that. Yeah? So whether it's been done through qualitative studies or through quantitative studies, they've all ascertained and all reached precisely the same conclusion, that there was very limited understanding and there was very limited work done to ascertain whether or not the signing of a BIT would lead to an increase in investment flows. Yeah, and the studies which have been done subsequently still haven't been able to reach any conclusive determination. In those circumstances, and I have no skin in the game, because it's not that I have to defend one side's position more than the other side's position, but it seems to me that it's an absolutely valid exercise for a state to reconsider whether or not the regime works for it. Yeah, any state would do it. Most states are in fact doing it, and therefore, not that Kate criticized India, but I think others do. And I I oppose that criticism. Every state should do it, and it in fact is a sign of a mature state, that it is reconsidering regimes that it has created for itself, and it is deciding whether or not it works for it after having gained 20 years of experience. In fact, it's so serious about it that the Ministry of Finance is going out and actually mandating people to conduct studies to determine what precisely is the impact. So I have been mandated by the Ministry of Finance to conduct a study to precisely study this relationship. Yeah, and again, they would not do it, and they would not want that study if they were not serious about understanding the pros and cons of the BIT regime. So I think we should keep that in mind. Now, and that's very relevant when you think about terminating BITs, because it's not just simply, I think, an action-reaction kind of a situation where, well, white industries happened and X happened and Y happened, therefore let's get away from all of this. It's also someone actually sitting there and trying to ascertain what works. Yeah. Now, one could of course criticize the model BIT as well to say that, look, you're taking away so much from it that there's nothing left. But again, I think that criticism has to be kept in mind of the original BIT regime not working, because no one had really applied their minds to it. In terms of the number of treaty awards, what you asked me, Piyush, I mean, no, it doesn't surprise me. It's a large economy. Highly decentralized, where each level of the government has substantial powers. Kate took the example of Nissan. It's a great example, right? You would never have that issue in, let's say, the United Kingdom, because ultimately state governments, it's not a federal setup. State governments don't have powers like they do in India to impose tax and make promises to investors. So in a large economy like ours, it's bound to happen. And would there be reactions when cases get lost? Of course there'll be reactions. US is a federal system. It has not lost a single case. But when it came close to losing a case, Lowe in the US, which most practitioners know about, it did have massive repercussions. They are also reconsidering NAFTA for a variety of reasons, or in fact did renegotiate NAFTA for reasons which are similar to the reasons that India is looking at the IT regime. So, I mean, I think we've got to sort of balance those considerations and be mindful of this fact that there are 20 cases outstanding against the government of India, or whatever number it might be, some it has lost, some it has won, that Videocon got lost and India didn't pay up. I mean, that doesn't really change the underlying dynamic, right? Because that's what a large country ultimately would face. But just that view on that.
Thanks, Rishabh. Before we move on, we have a lot of questions also coming and we're running short of time. Niti, can I just quickly have your comment on this change from 1994, where India signs the first BIT, and there's a number of BITs are signed, but now we are in this, at the stage where what Kate was highlighting is that now we are terminating BITs. And to an outsider, looks like we are being defensive to our position, where you're deleting all fair and equitable treatment clauses, etc. Your quick comment on this before we move on to the last part.
So it kind of also reminds me of how, that I've been practicing law for far too long. But the first time I started looking at India's BITs was many, many, many years ago, actually before the 1994 version of BITs. And actually India used to have investment treaties, and including bilateral and multilateral ones, but they had no dispute resolution clause because India didn't, you made an investment, but India was a recipient state, but very mindful of the fact that it was a recipient state who would be exposed to litigation and potential claims, and therefore those treaties never had any dispute resolution clause. It had to be state to state. It could not be investor to state. And that changed in the 1990s because India, as we all know, opened up its economy. It, however, did need investment, and this was one of the responses that India needed to put in place, was actually negotiate a new set of bilateral investment treaties which allowed protection to investors who were now being invited in. So, I agree. I absolutely agree with Rishabh that countries are entitled to revisit, re-examine. They should, in fact. It would be remiss of a government to not sit down and look at what is going on with it. The one thing that I will say, however, is that I actually don't see India's track record on BITs to be, let's not mix up India fighting international commercial arbitration, where it fights cases as it always does. Those are fought at a ministerial level or department level. it's a litigant and it's fighting and challenging awards, as I would if I was a private litigant. I don't see why India should not defend its commercial interests in the same way as other private entities can do. But where it's an international treaty record is concerned, or treaty claims is concerned, I think India is a mixed bag. I'm not necessarily seeing India as having refused to, I mean, the Nissan case got settled. We can look at it that way. The India has won, I think one of the Astro case, they won that one. They've recently succeeded in the Louis Dreyfus matter. So it isn't all bad news. And therefore, I think some of the reaction you see from the government, which is, it's all bad news and these international treaty claims are all terrible and we must withdraw from it. To me, I'm a little perplexed by that reaction. I think revisiting, re-examining is fine, but for a country like India to say, oh, I'm going to take the fair and equitable treatment clause away, you're too big and significant a player to have that sort of reaction. I mean, that's just me being an Indian and saying that I don't see why India needs to go that far. But that's also a conversation for another seminar, Piyush. But I mean, that, to me, just does seem overly. But I mean, let's see how it plays out. It's still work in progress. I think they're still negotiating new treaties, and we'll see how it ultimately ends up and where they finally land. Right.
I'm glad there is some disagreement among my panelists on this. So far, everybody seems to be agreeing, and we'll wait for the empirical studies that the government is doing, and which hopefully will give us more insight as to why some of the things have been done. Let me come back to you, and we'll be wrapping up soon. So what's clear from the discussion from what all Kate, you and Niti mentioning, that there are a number of arbitration, VIP arbitrations especially, going on. Now, in this specific case, in the Vodafone case, the tribunal's decision is against India. And there are other reports as well that there are other similar cases pending, before the tribunals. Is this likely to impact other, decisions? I mean, my specific question is that, is the principle of stare decisis applicable in international arbitrations?
See, that's the easiest question to answer among all the questions that you asked. The immediate answer is no. I mean, there is no principle of stare decisis, and therefore there is no impact. That's the end of it. Yeah. Now that's the legal answer, and there could be no. I think there could be no qualm about that. Now, but what's the reality? The reality is that it does look a lot like a system which follows the principle of stare decisis or precedential value, whatever you want to call it. And that's just because the way it is. Yeah, that's just because the way the lawyers have made it out to be and the way the arbitrators have made it out to be. So, 5 years ago, I did a study which got published as an article called "Who's the World's Most Influential Arbitrator?" Now, when I was doing that study, we, along with my co-author, we built a database where we took about 650 decisions. There were only 650 decisions at the time, which were published and publicly available as of 31 July 2015. And we started doing citation analysis on that. Yeah. Now, when we did citation analysis, we found that in total, those 650 decisions had cited about 5,500 times other decisions. Yeah. Even though there's no principle of stare decisis, 5,500 approximately citations existed. Yeah. Now, why were they citing it? And which decisions got cited more? Now, what we found was that obviously there are lots of factors that affected that. One was the length for which the award is available. Yeah. So if the award gets published today, it's not that tomorrow it will have its maximum impact. It will probably have an impact 5 years, 7 years, 10 years down the line, when others have had an opportunity to digest it, think about it, and so on and so forth. So the most cited decision, at least as of that time, was Monde v. US, which received 103 citations, but the maximum citations it received was in 2010. It was published in 2000. Now, to answer your question, would Vodafone decision have an immediate impact? The first question is, well, obviously no, because it's not publicly available. If it's not publicly available, what impact it's going to have? The second is that even if it becomes publicly available in terms of any sort of persuasive precedential value, it needs to be out there for some time. Yeah. And then, of course, what we also found in the course of doing that study is that all depends upon the quality, the depth of the legal analysis, and to what extent it presses upon certain novel issues which subsequently become relevant in other cases. Yeah. So, for example, TECMED v. Mexico has been cited a lot, but it has been cited a lot because at that point of time, it was the leading decision on legitimate expectations, which has thereafter become the most common ground to invoke, in the investment treaty arbitrations. So, immediate answer, no impact, should not have an impact as a matter of law, because there's no principle of stare decisis. As a matter of practice, could not have impact until the decision becomes publicly available, and it will take some time. Now, does that mean that it will not have an impact in public discourse? Of course, it would have an impact in public discourse, right? So newspapers would write about it, you and I would talk about it. But as a matter of pure investment treaty procedure and practice, would it have an impact? I don't think it would have any impact till it becomes publicly available.
Right, right. That question was easy, but your answer was interesting, actually. Rishabh, I mean, we have to now wrap up, and the multi-billion-dollar question is, will India, looks like India is going to challenge it. I mean, briefly, can you give us some pros and cons of challenging this award?
I mean, look, it's all crystal ball gazing, right? As you said at the beginning. Let's take a step back. When you advise a client on challenging an arbitration award, whether it's treaty award or a commercial award, what kind of factors do you take into account? The first most important factor is you look at the award, you ascertain whether or not there are flaws in the award, and whether those flaws fit into the limited grounds that may be available in the relevant Arbitration Act to challenge. Yeah. Now, I cannot comment on that in the absence of actually having the award in front of me. So how do I know that there are flaws in it or not? What are the other factors you take into account? You take into account how long it would take. Now, this would be before Singapore courts, who are known to be very efficient. So perhaps it wouldn't be that long. The cost involved, because if you lose, you probably have to pay the other side's cost as well. And lastly, and perhaps most importantly, in the present situation, strategic considerations. So by, for example, challenging the arbitration award, are you sending a signal to other investors that, look, even if you win against India, the battle wouldn't be over then and there. You would have to, in fact, go through a lengthy challenge process as well subsequent to it. Or do you genuinely believe that you have a good case to challenge it, such that those conclusions which are reached in this arbitration award, of which none of us on this panel are aware because we haven't seen the award, but if those conclusions are overturned, would that send the right message to other investors who decide to bring claims in the future? Now, in the mix of all of this, there is that one paragraph that the Solicitor General has issued in terms of his opinion. That just sounds, if you read it in isolation, if that's the entire reasoning, now that's very flawed, because that reasoning seems to be premised on the idea that simply because an investment treaty tribunal has found something which is contrary to what the state legislation says, therefore the award should be challenged. Now, we all know that that's not how public international works, and that seems to be flawed, but I doubt that would be the entirety of his opinion. What has come out in the public perhaps are 4 sentences of a much larger opinion. So again, no answer for you except factors that one could take into account.
Right. The time is running out for India to challenge that award. 64 days out of the 90 days. So time will tell what happens, Let me come back to the second aspect of the same coin. I mean, of course, you can challenge the award at the seat, but what about enforcement? If there were to happen any enforcement proceedings in India, and there are Delhi High Court judgments, and this is actually a question from one of the attendees today, that do you think that the BIT award would be enforceable in India under the Indian Arbitration Act, given the reservation that India has made to the New York Convention? Your reaction to this, and what would Vodafone do if they were to enforce this award in India?
Right. So again, look, it's very hard to comment on any of this without having the actual arbitration award. But my understanding is that there's no damages portion to this arbitration award. So this is one of those few investment treaty awards where actually it's effectively declaratory relief, as opposed to it being pure damages award. Now, there's a cost award, but let's keep that on the side for a second. Now, in circumstances where there is no monetary damages award, there's very little to enforce, right? Because typically what would happen, you'll get a damages award, you would then decide that you would make a demand to the state would not pay or not respond to your demand, and thereafter you would decide where to enforce it. And typically what you would look for is where are those assets of the state available, which are not covered by doctrines of immunity and so on and so forth, that you can execute the award against. Now, in the present circumstances, where to the best of my knowledge, and that's based on whatever I've read in newspapers, there is no damages award. There is, in that sense, no real enforcement to be done. The enforcement is to be done in circumstances where the respondent state does something which is contrary to the declaration or the dispositive portion of the arbitration award. So in reality, it seems to me that for the claimant of Vodafone, for example, the time to enforce comes only when the state does something which is contrary to what the arbitration tribunal has ordered. Why would it preemptively enforce? I would never enforce. So for example, let's say you and I enter into an arbitration and you've terminated the contract. I go to the tribunal for a specific performance remedy, yeah? And we get the remedy. I get the remedy. The tribunal says the contract is valid and you should continue to perform it. What's there for me to enforce in that? When you start breaching the contract again, that's when I go to the court. Otherwise, I don't enforce it. So I'm not really sure where enforcement fits in. And the New York Convention point is wrong because the reservation around that it has to be commercial and all that just doesn't work. Because it's a commercial dispute. The fact that it's a commercial dispute under a treaty as opposed to a contract, that doesn't make it any less commercial, right?
Right. Yeah, interesting. Actually, the meaning of commercial, and we'll probably hopefully see, what is the meaning. I'm reminded that the time is running out, and we actually have an interesting comment, and I would like, before we end, to get a quick comment from each of the panelists. Now, this comment is from Professor Lawrence Boo, and who highlights that in the 90s when India signed up on the BITs, India was, as everybody recognized on the panel also, was importing capital. But now the situation in 2020 seems to be changing, and India is looking, as the economy grows bigger, that we'll be exporting, to other states in the world. If the BITs are terminated or stripped of this investor protection, what comes about is that Indian investors will also lose the protection, and the current investors in India are enjoying actually, because of course, Kate was mentioning about the sunset clause that will take a few years. I mean, the termination is not going to be immediate. So is this a situation where India is actually shortchanging itself? Maybe I see your head nodding, maybe we can start.
Well, I mean, I actually have spoken about that earlier elsewhere. And it kind of ties into the point I was making earlier, which is when the Delhi High Court says that the Arbitration Act will not apply, it effectively, limits India's ability to act as a host, as a seat for arbitrations. And I think that it's a perception issue, really. When India says we're not going to agree to FET, we will not. It's forgetting that now India is a different economy and a different country from 20 or 30 years ago. And one of the big concerns, and I think Professor Boo points out correctly, that India now has its own businessmen and its own businesses who are taking investments outside India. What happens to them? The protection that these treaties would have offered those investments is going to be withdrawn from them. So it is certainly a matter that India should, as I said, I mean, I think it's all work in progress. These are issues that are being considered. And I think it is for Indian industry to have that conversation with the government of India and say, look, those protections work both ways. You protect investments and then you protect your own businesses who take investments outside India. So I think it's an absolutely fair point and something that the government of India should be mindful of.
Keith, would you like to add anything to what Nidhi just said?
No, I think I agree with Nidhi and with Professor Boo as well, that it may affect India's investors negatively.
Right. And Rishabh, do you agree, disagree, or do we have consensus at the end?
No, absolutely agree. I don't think you could disagree on that point. But, the reality in all of this is that that's, again, a very important consideration that the state does take into account in ascertaining what regime to build. And if you look at the historical BITs India had, the ones which have now been terminated, we didn't have BITs with most of the African countries. We didn't have BITs with any of the Latin American countries. So when Venezuela, for example, introduced price controls, a lot of the Indian drug manufacturers suffered hundreds of millions of dollars as losses because the money couldn't come out. And the generic industry in India, which supplies drugs to Latin America, in particular to Venezuela, suffered a lot. Again, the point is not agree completely. Reciprocal protection is very, very important. But also someone needs to sit down and think which countries you want to have BITs with, right? Because it's not just, these are strategic decisions, and those decisions should be made in a strategic manner, as they were in fact made in the first instance by the capital exporting countries when they were entering into them, right? So completely agree with Professor Bu's point, but I think you add on to that historically India wasn't clever enough to decide where those investments would go, right? And this time around, I hope they would be clever enough to do that.
Okay, thanks. Thank you, to all, Neeti, Rishabh, Kate, and also to Shama. What's interesting is actually that looks like we have made some progress, but there is still a lot to be done, and we probably need to go back. India needs to go back to the drawing board and see, both in terms of termination of the BITs, getting into new BITs, and of course, I think probably most importantly, not to leave the void in the legal regime, which will, on one hand, where India is trying to be the seat of arbitration, not to exclude BIT arbitration from that fold. And secondly, coming to this particular decision, it remains to be seen what will happen, whether there will be challenge in the Singapore courts, or what happens if and when Vodafone decides to enforce that award in India. I mean, and as Rishabh was pointing out, that of course they will need some impetus to do that. It will depend on what the reaction of the Indian government to all this. On a lighter note, I recall that Vodafone made a very catchy advertisement which said that wherever you go, our network follows. And for the discussion today, it remains to be seen if this dispute follows Vodafone or the Indian government, whichever way they go. Thank you so much for joining us. I would like to finish by thanking all the panelists, of course, and also to our attendees. We had over 350 people sign up for this event from all over the world. Thank you so much for joining us. Lastly, I would like to mention that YSIAC is launching in the Americas. We will commemorate the official launch of YSIAC's New York office with a virtual launch ceremony and a series of online programs starting next week from 2nd December to 4th. Please check our website for more information, and I hope you can join us on this big launch in the Americas. That's it from me and from all of us. Take care and stay safe.
Thank you.